the remote people. Okay.
California coastline.
I see the comments possibility. Okay, I see it right now. Good. Some comments window I have. It's also okay. People start coming here. Okay, so I think the people can see it. Okay, so we are online and we can start. Yes, I believe.
Okay.
Okay, so there are some viewers already, so we can start, and we will provide a great performance today, I believe, and that's it. So we start now. I will also right now open the window with comments so I could see it. That will be great, I believe. Yeah, I see the comment window. I'm very happy with it. So goodbye, good day, everyone. Here am I, Anton, and also Paulina, and today we have a great webinar about legal tips and tricks for IT companies in Poland and Ukraine. And for now we start. I will tell a bit about myself, then Paulina tell a bit about herself, and then we'll continue to our agenda. So my name is Anton, I'm from Legal IT Group. We are a Kyiv law firm. We provide special services of legal services for IT companies, and it's great. I have, as me being as IT lawyer maybe for 5+ years, I have made a lot of documents, GDPR compliance procedures, I don't know, IP contracts, tech consultations and so on. And I really do hope that today we will give you some really useful material that you will be happy to share with your friends or use in your own practice and so on. And Paulina, can you tell a bit about yourself maybe?
Hello, my name is Paulina. I'm from Poland, and I'm actually talking from the different time zone, which is kind of funny. And and I'm an attorney. I have over 7 years of experience working in a law firm. Currently, I'm running my own law firm, and it's specializing in IT and digital law. I cooperate with companies and developers all over the country. And I think this webinar is going to be very useful for everyone.
That's great. You can see the different achievements of Paulina right now. She's an attorney, she's graduated, she has 7+ years, and she's very cool. So we can start today our topic and our agenda. I will talk about our agenda, and then Paulina will talk about all the stuff regarding Poland, and I will talk about the stuff regarding Ukraine, and it will be great. So today we will talk about IT contracts, IP rights, taxes and obligations. So what is important in IT contracts in Ukraine, in Poland, what is important in Ukraine in IT contracts between Ukrainian and Polish IT companies, and so on. Also we'll talk about GDPR, specifics for Ukrainian compliance and for Polish compliance, because there is much difference. And also we will talk about the ways of involving Polish and Ukrainian developers legally. How can we do it? Labor relationships, co-workings, private entrepreneurs, taxes, and all this interesting stuff. Okay, so let's start. Paulina, and that will be your kind of speech about taxes and in Poland, what are they, how do they work, and so on.
Okay, so let's start with differentiating the employment contract and the B2B contract, because there are some different kinds of obligations for each side. And starting with employment contracts, the developer being employed on an employment contract is obliged to pay the personal income tax, which is 18%, and then it becomes 32% after reaching the certain threshold, which is, I think, over 85,000 zlotys in a year. And on the other side, the company that's employing the developer is responsible for all social security payments for the developer, which they all sort of come up to about 20% of their entire salary. So it's the salary plus the 20% for the all of the social security payments. And the cool thing is that the company that's the employer can kind of account all the costs that they're spending on the employer, including the payment and including the social security payments. They can all be accounted into as costs of their activity, so they can pay smaller income tax. Okay, so that's about it. That's about it with the employment contract. And if we are going to talk about the B2B contract, it's kind of more comfortable for the employer, for the company, and most companies prefer developers to be on B2B contracts because it's for the developer to pay all of their income tax, all of the social security stuff, so the company doesn't have to worry about it, and it's actually preferred. Is it so in Ukraine? Do they prefer to the B2B contracts or the employment contracts? How is it, Anton?
Well, in Ukraine, the situation is as follows. Most of IT entrepreneurs work as, if you can say, like they provide services as private entrepreneurs and pay only 5% of their tax, being on a unified system. And some people say that it's not fair because sometimes entrepreneurs use it to avoid taxation and so on. But on the other hand, the system works today like this, and most of IT sector works in this manner. And that's the way maybe it should be in our country, because it gives really extensive development and intensive development of IT sphere, IT branch here in Ukraine right now. It's really interesting. On the other hand, some companies from USA or from UK who make some subsidiaries here in Ukraine involve developers, making with them some labor relationships and pay the 42% of taxes. It's also really interesting because they want it all to be truly legally. It's also so the same situation is you can hire a developer in labor relationships, pay more taxes, or you can involve developer as a private entrepreneur. In each case there are specifics, there are risks in some cases, but there is the industry and the market that works the way it works really. Also here in Ukraine we have VAT tax regarding the business, but in IT branch, really if Ukrainian IT company provides services abroad and in B2B, then there is no VAT. So most IT companies, they don't pay VAT at all. That's the thing. And what about VAT in Poland? Do IT companies pay VAT in Poland?
Well, yes, actually, it's IT services have the 23% standard VAT, so we don't have this cool discount that you do. and if you it doesn't matter if you transfer IP rights or not. It's if you have a B2B contract with your developer, you do pay VAT. You don't pay it if you have an employee, and it's and it's just the salary then.
Mm-hmm. And I heard that in Poland there is such case as creative tax on creative services. Is it widespread in IT branch? Do IT companies use it or no?
I think what you're talking about is the kind of 50% reduction of tax if you transfer IP rights to your client. And if this is what you mean, then some IT companies use it, but it can only be used when you have an employment contract or when you're hiring a person who isn't an entrepreneur. So it doesn't work for B2B contracts. Mm-hmm. But it's kind of it's used with employees. Quite widely.
Cool. Okay, let's move further. So IP rights in Poland. What are the main problems maybe with IP rights transfer in Poland? What are the main trends? Can you tell us about it?
Yeah, the most important thing, and some companies forget about it, it's that to really transfer IP rights to your client, you have to have it in written form. Mm-hmm. And written form means like printed out on paper, signed by hand by both sides, and only then you can transfer IP rights like fully to your client. And many companies who actually are responsible for preparing the contracts with their developers, they forget about it. And I've seen so many contracts, with these huge software houses, huge IT companies, who don't even write anything about the transfer of the copyrights to the program, to the code written by the developer. And it's really problematic because they actually don't own the rights, and the developer works for like 3 years and then leaves, and they have a problem because they really legally shouldn't be doing anything with the code, with the program. So it's very important to remember to do it in writing, and both sides should make sure they do it properly. Also, the second important thing is to remember about determining the fields of use, which is actually saying in the contract what you can do with the IP right, with the code, with the program, and they should be as specific as possible. And only then, in written form, with the fields of use, it's only then that you actually transfer the rights properly. So it's really important to remember that. Is it the same in Ukraine? Do you need a written form to transfer IP rights?
Well, yes, we need, but on the other hand, we also have some amendments in civil code, and it is a case that electronic documents can be used as written ones, but only under some conditions. And from my point of view, it's always better to have a printed contract, or at least to have it signed by some software, and in this case it will be okay. But if you don't have a contract and just send letters to each other or invoices, it will be some kind of problem. Also, regarding the transfer of IP rights, well, sometimes when you work with USA customers, USA companies, they just provide us even with some clauses that they say we need such clauses in all contracts with developers. In any case, because they believe only in that case the rights will be transferred. But on the other hand, that's the standard clauses like the time of transfer, when it's transferred, and what is transferred, and what rights are transferred. The other situation is when some companies prefer to avoid transferring and to state that IP rights belong to the customer from the moment of his development, from the moment of its creation. It's also okay, it's also good. The main idea here is that you have to state it in the contract, because if you want that, then you will have some problem with it. It's really true. Yes, that's the situation. On the other hand, there are different contracts when when customers state too much regarding IP, too many fines, too many inadequate clauses, like you have to protect us against everything, against any comet that falls upon from sky and so on. But you just have to state what you just have to state. That's true. Okay, let's move further. It's about NDA and CA in Poland. Paulina, can you tell me, are contracts like NDA and non-compete agreement well spread in Poland, and do they really work, and are they actually, can we use them in court and so on?
Yeah, well, actually, they are very popular in contracts, and they're usually just like incorporated in the cooperation agreement, or the NDA is a separate document. And they are very popular, but they're usually really badly written because, as you said before, people tend to, just write it a little bit overboard, and say that you can't actually do anything, you can't tell anyone, and if you do, you'll have to pay like 5 million euros of penalty. So every time you have someone tell you to sign something like this, you should really read it, because sometimes you can make yourself liable for huge amounts of money after not really doing anything serious and not causing any serious damage. So it's you always should be like trying to even out both sides and see what's really necessary if the penalties are not really too high. So yeah, it should be. You should all make sure that it's all understandable. That the developer usually is the one obligated to comply that he knows exactly what he cannot do and for what amount of time. And it is very popular in Poland to kind of forbid the developer to work with anyone who is a competition to the company, and not only during the actual contract, but also like 3 or 5 years after the contract has been terminated.
Is it legal?
And yeah, sorry.
Is it legal? That such problems for the developer, like 3 or 4 years after all this stuff, and he cannot work with someone. Is it legal at all?
Yes, it is legal because in a B2B contract, both parties are equal. So it's it depends on them what they agree on, and if they did agree on something like this, it's legal. So for the developer, if you are the developer, remember to always fight for compensation, because during those 3 or 5 years, sorry, you are actually you can't work, and your possibilities are really limited. So you should demand that you are compensated for it, and usually it's done. So you write. That during those 3 or 5 years, the developer gets like 50 or 80% of what they gained during the contract. So it's kind of compensated for that they are their possibilities are limited. So make sure that you get compensated, because it can really get unfair. And after you sign a contract like this, your possibilities of fighting for compensation will be limited if you don't write it in the first place.
Really interesting, because in Ukraine, some people say that non-disclosure agreement don't work at all. That's really interesting, because but on the other hand, we believe they work, and you always should sign non-disclosure agreements with the team, maybe sometimes with the clients and with your other counterparties, because if you won't sign it, then you will have any legal ways to protect your interests and so on. Also, I believe that NDAs should be really customized, because if you just state all the information from some standard NDA, it may not cover the topics really you need. For example, for NDAs in gaming industry, in game dev, you have to state all the concepts of the arts, of the possible ways to create a character, and so on. On the other hand, talking about NCA, about non-compete agreement, there is a limitation in Ukraine. So the non-compete agreement, they won't work like in Poland, because we have some imperative clauses in commercial code that states that each party may choose its counterparty, and no matter what. And so it will be really hard to make the NCA enforceable in Ukraine. On the other hand, if the Ukrainian developer will sign a contract with some American company, and they will regulate it with American law, the law of some state, and in this case it will be liable, and it will be enforceable, because we will use the other legal order. It's really important as well to understand it. Okay, let's move next. It's like obligations in Ukraine. Okay, so Paulina, maybe I will ask you a question. What kind of contracts usually sign IT companies in Poland? Is it time and material contracts, fixed price contracts, outstaff contracts maybe? What is the most well spread model?
Well, I can give you the most lawyer-like answer to your question, which is it depends. Because actually, both time and material and the fixed price are actually quite popular. Maybe the time and material is getting ahead a little bit because of the whole agile contract idea. So yeah, it's the agile model is actually a little bit more trendy now. So I guess the time and materials will be in the first place, but the fixed price is also quite popular. So it's hard to say really. It depends on the actual subject of the contract.
Yes.
But what is it like in Ukraine?
Well, here I think the agile model is the most popular, the time and material, because it's the best one for developers, and they really like it, because you can amend the tasks then you can actually bill and make invoices for all amendments. And when it's fixed price, and sometimes customer wants more and more, and it's hard to bill him everything, to invoice him for every change. On the other hand, I see many requests for development of contracts like a time and material, but with advanced payment for some money, and then just this money is just transferred and used to cover all the expenses that arise along the way. It's also really interesting, and sometimes there is some payment, for instance, $5,000 per month, and some planned hours, some planned working schedule, and after it, parties just say, okay, this month we used more hours, so we have to make a payment one more time, or we just have to make this payment available for the next month. It's also okay. And also I wanted to talk about this such thing as buyout clauses. Like if you have a developer that works for your company, and then and you work for a client. For instance, your client very much likes your developer, and then he just says, okay, I want to work with him directly. And you say, oh no, please, it's my developer, no, please. And he says, I will pay for him. And you think, okay, how much should I charge? Maybe 1 monthly salary or 2 monthly salaries? Or does the developer even want to go to work directly on the client and move to some other country, or maybe to make it on freelance? So sometimes in the contracts there is this buyout clause, and it states like something like, if the client wants to work directly with the subcontractors or any partners of the contractor, it has to pay 6 times of monthly payment to such subcontractor, and he may involve him. But on the other hand, will the developer wants such model or not? Are such clauses well spread in Poland? Did you work with them? Maybe did you have some such cases?
Actually, no. I'm kind of listening to you with interest, because it's kind of new to me, and all the contracts I've seen so far, I haven't seen a buyout clause like this. It's usually NCA, and you can't work for anyone. You're a slave, and for like 10 years after the contract, you still have to work with us, and you can't work with anyone else. You can't do it, on your own. So no, it's not very popular, but it's kind of cool. I think it's like appreciating the person, the developer who works hard and gets noticed by someone else. It's really nice. I think Polish companies should apply such clauses in their companies, and I'm gonna try to convince some of my clients to do it.
Yeah, it's a really interesting thing, because talking about all this stuff like NCA, and you can say something like, and your son will have to work on our company. You have he has to study to engineer, and we will actually produce his future, and his son will also work for us for 10 years. It's like it's like back to sometimes when it was also legal. It's really funny. And regarding all these buyout clauses, there are different point of views of Ukrainian lawyers. Are these clauses legal? Is this can we do so? For example, you can take a look at football market. When they have a contract and they have different clauses that state, okay, any party can ask our team to terminate the contract with the footballer and to get this footballer to their team. But in this case, they will have to pay us, $50 million. It works in football because market is like this. So I believe that in IT it also should work, and sometimes it works, all these buyout clauses. But it works in case there is no conflict. Sometimes there are situations that some Ukrainian company just created this brand and then involved the developers, and then just the customer says, oh, I know your developers, I will work with them directly. And the problem is that Ukrainian company does not have even contracts with the developers, and the developer says something like, okay, I will work directly, and you can nothing do to me. And in legal way you can nothing do really, and it's some kind of depression for the IT companies. But on the other hand, you have to protect your interests and make really good contracts. So it's life. Okay, so let's continue then. we will move to personal data protection to GDPR. And maybe some words from you, Paulina, about GDPR in Poland. What is the situation right now? Maybe there are some fines for Polish companies, or some cases, or maybe something really interesting. And I think our viewers will gladly listen to you about all this stuff. Yes.
Of course. Poland is the member of the EU, so naturally GDPR is just become a part of our legal system, and we just have to, everyone has to comply. So there's no question about that. And I'm actually really interested about Ukraine, but you're gonna speak about it a little later. As for Poland and Polish companies, actually GDPR needs to be, everyone needs to be in compliance with GDPR, and even the single entrepreneurs and the huge companies, everyone. Of course, the huge companies are at more risk of some data leak, and they deal with more important and bigger data. But even the single entrepreneur, if he's dealing with clients and he's exchanging some emails, he's invoicing, he should have this whole data processing thing applied in his company. So you have to design data flows, you have to actually make this audit and see what kind of data you're processing, and it's customers, it's employers, it's your contractors, and always have in mind that you should only have and collect and process the data that are actually necessary. So don't try to collect some extra data just in case, because in the future you might want to, send a postcard to your customer, so you need their post address, because actually sometimes you don't even need your customer's post address if you have their email and, their name, and they pay you. So, you don't always need all the data that you think you need. So everyone should really think carefully about collecting each piece of data separately. Also you have to, if you have a website, if you're offering a newsletter on your website, or maybe you have this contacts box where everyone can write their email, their name, and a message to you, you should make sure that your website is compliant with GDPR. You should have a privacy policy implemented. You always have to think about data, even about personal data, even if you don't actually realize that you are doing anything with them. So website should be compliant, as well as every app, every program you create. You always need to think about personal data, about GDPR, when at the beginning of designing anything, really, because there is this GDPR rule, privacy by design and privacy by default. So when you design something, you design an app, you design a program, you should always think about how the personal data is going to be handled, and what kind of data you're going to collect, and what kind of data actually has to be collected. So everyone, even these small entrepreneurs, as well as the huge companies, everyone needs to comply with GDPR. And it's been a year and a half since GDPR has been implemented, and we already have some cases of huge penalties put on Polish companies for not complying with GDPR. And one of the biggest cases, I think it was the first, but I'm not really sure. It was about a company who actually collected other people's data from the internet. So like from this single entrepreneurs database, which is actually available for everyone online. So they collected the data, the email addresses and their names, and they I think it was they sent some kind of offering to them. And GDPR requires you to inform everyone who didn't give you their data by themselves that you are actually processing their data. So they didn't do it in the cases which required them to send these paper letters, like by post. They had to send them to the companies. So they didn't do it. They only did it to the companies that actually gave their email address. And those people who didn't receive the information, it was a GDPR breach. So they paid a huge amount of money for this. And it's kind of weird because the data was actually available online. So even if you do that, you have to inform the people that you're actually doing something with their data, even if the data is available online.
Yeah, it's kind of interesting case because here in Ukraine you also have all these registers, and actually there are a lot of different stuff like different bots and different parsing systems that just look through the internet, and you can type some kind of name of some man or woman, and then you will get where he is a founder, director, and so on. But on the other hand, we have some other legislation. We have law about open data and access to open data law. I think it will be correct name of it. And there are the ways you can use this information and limitations and so on. So it depends really, and there are also clauses regarding use of such personal data, and it's really interesting case you just told. Okay, and we have some questions for you, Paulina, and the question is as follows: does Polish law add more details complicating the overall GDPR compliance for Polish and foreign companies? Thanks. Yeah.
Well, it's an interesting question. Thanks for that. Well, the Polish law has only actually recently kept up with GDPR because GDPR has become the part of our legal system without, our legislation needed for that. But there are some Polish legislation, Polish acts, which actually kind of make it easier for Polish companies to comply with GDPR because it kind of gives us specific directions in some areas, like in the labor code, for example. So, every employer knows how to deal with some bits of their employees' personal data and so on. So there is even some law for lawyers. So I can, comply with GDPR, and I know what I can do with the data of my clients. So I'd say it more helps than makes it more complicated.
Okay, that's really interesting. And then let's move to GDPR and Ukraine. Companies, actually we have a lot of cases when we worked with Ukrainian companies implementing GDPR for them. One of the most funniest and interesting cases, as for me, it was not for IT company but for hotel here in Kyiv, and they work mostly 99% of their activities aimed to get the European customers. So they have different websites when they try to involve some customers to book the hotel room, and their marketing was focused on EU and so on. So they wanted foreigners to come here in Ukraine and be in their hotel. On the other case, they also took a lot of their data. For instance, they just stated that, okay, this guy has come to our hotel and he was here before, and he likes this kind of breakfast, and he likes this kind of pillows and so on. And so it's all personal data, so they had to be in compliance, and it was really interesting to make it for not IT company. On the other hand, we have different companies that work in different branches, like for instance arbitration of traffic and all this stuff. When you work with these cases, you have to delete some numbers in IP addresses when you transfer them. You have to encrypt it very difficult way, and it's also very interesting. The main activities, the main interesting cases in Ukraine for the companies is to understand really when do you need this GDPR compliance. The best answer will be as follows. I always ask people here in Ukraine when they come to interview to our company, the junior lawyers, about some fun case. Okay, you have a hot dog track here in Kyiv, and you sell hot dogs. and then some guy comes to you and says like, okay, hello, my name is Gans, I'm from Netherlands, or I am from Deutschland, and hello, I am 35 years old, here are two my daughters, we like such kind of music, you can find us here, please sell me a hot dog. And you know this information, you just say, okay, now I know this information, and you're a European, please sign all these papers, I don't know, all these 100 papers, and then I will give you a hot dog. And the question is, does this hot dog track need to be in compliance? And some people say that yes, of course, because he knows the data of Europeans. And I say, why? But he didn't want to know it, and he did not even have a website, and he does not have advertising on European market, and he is just here selling for hryvnias the hot dogs. So in this case, he will not need the GDPR compliance. But in case he would have a website and focusing on Europe and advertising his hot dogs on Europe and maybe with delivery, in this case, in case he would gain such personal data of Europeans, he would have to be in compliance. It's really interesting. Also, there are different cases interested in GDPR regarding the AI, the artificial intelligence technologies, also regarding the machine learning systems, how to involve them, how to use them, and how to manage them and create them. Also very interesting. So you just now you have to understand that really I liked that you said like to manage to design the data flows and to work with them from the very beginning. I think it's true in any case, and that's true. Let's move further. The final part of our webinar, how to involve Ukrainian and Polish developers legally. Actually, we talked about it a bit, but I think we will continue and summarize here some information. Okay, so involvement of developers in Poland. Okay, Paulina, how would you recommend maybe for a Polish company to involve some Ukrainian programmer to work with them?
Well, actually, it's kind of tricky because Ukraine is outside of the EU, so to the Polish legal system, every Ukrainian entity is treated as a foreigner. So there are some limitations, and maybe if a Ukrainian company based in Ukraine would like to involve a Polish developer who's a single entrepreneur. This wouldn't be a problem because there are many developers in Poland working like this for the USA and probably for Ukraine as well. So this is just going to be an invoice and figuring out the double taxation thing. So the VAT and stuff like that. So this shouldn't be a problem. Also, a Ukrainian company could open and register a division in Poland, and and then get to pay the income tax from the income gained in Poland as a Polish company. Also, there is another option for a Ukrainian company to just open and register a completely new entity, a new company in Poland, and separate from them. And it's usually quite popular among the Ukrainians who actually live or move to Poland. They can open this, the limited liability companies, and they're actually quite popular. And then, for all the small companies and all new companies, the income tax is actually very nice because it's only 9% at the beginning. And then after some time it becomes 19%. So it's actually kind of a good idea to think about opening a completely new company in Poland. Yeah, so that's it, yeah.
That's really interesting. Well, regarding involvement Ukrainian developers for providing services to the foreign companies, I may say that actually the private entrepreneur is a good option. That's a good option. And for foreign companies, they also may open a subsidiary here in Ukraine and involve their developers to this subsidiary in labor relationships or in contractor relationships and pay taxes and transfer the API rights to its the domestic company to its main company. It's also a way. Regarding involvement of developers who are not Ukrainians here in Ukraine, well, there were amendments in Ukrainian legislation, and for now it's possible, for instance, from guy from Poland, from Belarus maybe, and just to come here, get the ID number, the tax ID number. Yeah, tax ID number. Let it be like this.
Yeah.
And just open a private entrepreneur and pay taxes here. And also it depends on how many days do you spend here and the double taxation situation. But it's really not so hard to understand and to make it. And it allows this guy or girl to pay 5% of taxes. It's really good. Okay, we have some questions. And I will read it, and it's kind of a long way, but I will try. We have a very good law on data protection in Ukraine. The other question is how to make it work. If it worked, the personal data of Ukrainians would have been protected even without GDPR. Well, actually, Marina R. I really do agree with you in this case, because here in Ukrainian law on data protection, it's really the personal data protection. It's really there are different really good clauses. It was amended began to work in 1212, and it was amended by some time. And for now, we have a right for instance, to tell the company that I don't want to be the subject of automatic decision, or you can tell the company that you have rights and ask company to provide you information. Actually, we have a lot of good stuff here, but it is stated in a very generic way. Just okay, you have a right. But how can you use it, and what will be to the company if it prohibits it? It is not stated, and fines that are for violation of this law are really small, or they are not fines at all. And the problem is that companies do not fear this law like they fear GDPR, so it doesn't work in a good manner. On the other hand, I believe that regarding all this Euro integration of Ukraine, we will have to adapt this data protection, and it will be double law will be also amended. There are different things like profiling, for instance, in GDPR that could be involved in Ukrainian law, and it's really interesting situation. How can it change it? It's really good. Okay, let's move further. Here we have involvement of developers in Ukraine. Actually, I said all this stuff before, but one more word about coworkings. There is a trend that some foreign companies just involve Ukrainian developers as private entrepreneurs and tell them, okay, you sit in coworking right now and we will provide you a coworking. It's some kind of risky model, because some authority may say, you have labor relationships, will you just put it in this manner that it does not look like labor relationships, but it is.
Yeah, it's a big problem in Poland as well, and it's a very popular practice as well.
So actually, it's a trend. It's market. Companies do like this. Authority thinks, okay, not so good. But what can I do? By some time, some authority makes visit to some IT companies, and they say something like, oh, we are not protected. Help us. And it is in mass media and so on. And then it all comes down. And then again, and it's like it's market, it's life. Then
it's life.
Yeah, it means that it works, and it's a really interesting situation for lawyers, for instance, as well. Okay, let's move to conclusions. So I don't know. I will say some words. Maybe you will say some words. Well, I will say as follows: that when you construct the legal model of your IT company in Ukraine or in Poland, you have to think from the very beginning how would you regulate the IP rights and how will you be able to enforce the clauses in your contracts. It's very important. And what do you think about this, Paulina?
Well, I think I agree with you, of course, and I would add that, some people don't realize how important it is to write and, agree on the best contract possible at the beginning, because it's the beginning of the cooperation when you are actually on really good terms with the other side. So this is the best time to kind of, set all the most important points and regulate them in the contract. So, if in a few years or in a few months you come to a disagreement and you're in a sort of a war with the other side, then you can look at the contract and think, okay, so we agreed on that I will do this, and we agreed that you will do this. So let's do it, and let's not fight. So if you don't have a good contract, or you don't have a contract at all, and you just work on invoices each month, then when it comes to a problem, you might have a bigger problem than you think, because you won't be able to prove anything. The other side will say, I didn't agree on this, I didn't say anything like this. And you'll say, yes, of course you did. Remember, like half a year ago, you said that you're going to do this and that. And, it's your word against theirs. So always remember to have a good contract at the very beginning of your cooperation. And I would also recommend to, consult a lawyer, and preferably, if this is an IT contract, consult an IT lawyer who actually will be aware of more risks that, are waiting for you in the contract, and will, give you really, really good advice, and, just be safe.
Yeah, I really do agree with this. Also, I really liked your thesis about that you have to manage to create data flows to design data flows from the very beginning, because you can imagine some business model in your head using the different data flows and connected them and making them good, and improve the data of personal data of customers, and then you will just understand that it's not in compliance at all with GDPR, and all your stuff and all your efforts will be vain. It's really good to think from the very beginning. And that's it, I think, for today. Maybe I will make one more slide. On this slide you can find my contacts and my email at legality-group.com, and also you can find the Paulina email and contacts, and our logos you can find as well, and the wording "thank you for attention" you can find. Well, we had some questions during the webinar, and we hoped we answered on them. If you will have any questions more, you just can write us on emails stating something like, I was on a webinar, I forgot to ask you a question, and just tell me please, and so on. And we will be really glad if you make a like button, if you push a like button for this webinar, if you liked it, and subscribe to our channel right now. Yes, do it, please, subscribe. It is very good practice. We like people who subscribe to our channel very much.
Yeah, I already subscribed to your channel.
We like you more than some other people here right now. It's okay. So we really did like hear what we told. I hope our viewers also liked. And maybe some words from you, Paulina, for the very end.
Yeah, well, thank you for having me. I hope we will do it again sometime. And thanks for the good questions, and for listening to us for almost an hour. And yeah, have a nice day.
Okay, thank you very much. Thank you very much. Nastya, you can put us out of the live. Thank you.
Bye.
Goodbye. Goodbye. Are we out of the live? Are we yet? No? Yes? Right now? Yes? No? Okay, I don't know if you're alive anymore. Can I